Hello, everyone. Thank you so much for joining our monthly webinar. Peter Fitzpatrick and Sherri Dozier are leading today's training on civil processes under the workers' compensation umbrella. This will include 132a discrimination and serious and willful misconduct and how they cross over into workers' compensation claims. I always encourage you to visit our website at bradfordbarthel.com, where we have tons of information about Bradford and Barthel, our team, our wonderful attorneys, and our value-added services. I want to point out a few things that you'll find on our website. Our training page, number one, over 80 hours of CE credits available to claims examiners. I know some of you have your CE credits coming up that are due, I think, in June. So if you need those credits at any point during the year, you can watch our videos for free and get continuing education credit. You can also register for upcoming webinars on our training page. Our B&B attorneys write fantastic blog articles that you can also view on our website. And our AMA analysis and rating department fully analyzes and annotates medical report shortcomings, outlining sections that either need to be bolstered or undercut, depending on your objectives. We highly encourage questions. We always do. You can submit them in the questions section of your GoToWebinar panel, and we will try to get to a few of those during the presentation today. And with that, that's all from me. I think we're going to go straight into some introductions. Sherri, do you want to start us?
Thanks, Tammy. Yes. Hello, everybody. We're so glad to be here with you. This is an interesting topic, and I'm kind of excited to have Peter present the very important civil portion of it. And I'll come in with some crossover because I'm an old claims person. I've been with Bradford Barthel for 23 years, going on my 24th year, actually, coming up here, and in the industry for 37 years. Been around the block a little bit. So I'm going to hand this over to Peter. Here's our wonderful pictures. And Peter, go ahead.
Thank you, Sherri. Yes, my name is Peter Fitzpatrick. I'm an attorney at Bradford and Barthel in the subrogation department, and I will be with them 18 years this summer. So just as Sherri said, we've been here for a while working on these type cases. And our subrogation department handles civil matters, and the presentation today being civil processes and the crossover, we're going to be talking about the discrimination petition, the 132a petition, the serious and willful petition, and those have civil elements of proof to them that go hand in hand with the underlying workers' compensation case. And then there'll be other employment issues as well, layoff issues, return to work. Those are all intertwined. Okay, so let's get right into it. Let's get right into the presentation. Again, thanks for joining us today. I really appreciate that. I hope we can give you some good information and answer your questions as well. So what is discrimination? Well, that's prejudicial treatment of a category of people. So it's a protected categories, as they say in the legal field. Protected categories. In this case, we're going to be focusing in on medical disability. That's a protected category, but there's others that we'll be talking about as well that are protected by state and federal statutes. The state protection is the Fair Employment and Housing Act. That's the acronym is FEHA, and the federal is the Americans with Disabilities Act. That's under a federal code section. And then the first crossover type issue is workers' compensation labor code section 132a. That is used in the state type cases, or can be the same burdens of proof there regarding discrimination against a worker. Okay, so here's as I mentioned, this is the state law. This is what we use really, and what I deal with in my practice here at Bradford and Barthel. So this is California state law. It's a government code section 12940. is the government code section, and it protects people. These are the protected categories. Age is one of them, over 40. You cannot discriminate against someone who's over 40. And then all these other categories are involved: ancestry, color, creed, denial of family and medical care leave, disability, mental and physical, including HIV and AIDS, marital status, medical condition, again, cancer and genetic characteristics, all types of medical conditions, national origin, race, religion, sex, pregnancy, military services, sexual orientation. So under state law, they're all protected categories. An employer cannot discriminate or terminate someone based on one of these categories. And the definitions are a bit broader in the FEHA state disability protections. It goes a little bit beyond the federal ADA law, although it was fashioned after the ADA law. The FEHA state, they decided, you know what, we're going to add a few more things in, which they've done. Harassment is another protected category, where you cannot harass a person, an employee, male or female, based on one of the characteristics that we just discussed. And here are, as I was saying, it's medical conditions primarily today, because we're going to be talking about workers' compensation cases, which are physical and mental disabilities, medical conditions. And so it's any type of physical disability someone might have, including these body systems, neurology, immunology, all the different digestive, skin, all the reproductive organs. Those are all protected physical disabilities. And then mental is just as important as the physical. So I mean, it's easy to identify, a torn meniscus or something, an injury to someone's body. A little bit more difficult sometimes with the medical and psychiatric injuries, stress type injuries, but all those are protected. You have to be careful as an employer not to discriminate against someone because they have anxiety, for example, or some type of mental, psychological disorder. Okay, I think Sherri's going to take over the next slide.
Thanks, Peter. So FEHA and workers' compensation overlap, and that's kind of my part of this. It limits a major life activity, and here's where activities of daily living come in. Without regard to mitigating measures such as medications, assistive devices, prosthetics, or, and here's the bingo, reasonable accommodations, what we call return to work. FEHA, as Peter said, also includes the medical conditions. Medical conditions being referred to are any health impairment related to a diagnosis of cancer, or a record or history of cancer and genetic characteristics. Some examples are firefighters. They notoriously, unfortunately, get skin cancer. Or the use of the BRCA1 or BRCA2, which are the DNA tests to identify genes for breast and ovarian cancer. And we actually had a case not too long ago that we had two sisters who happened to have breast cancer. And they were making a claim against the employer that a chemical caused the breast cancer. Now, we didn't discriminate, the employer didn't discriminate using that DNA test. They did the DNA test, but when we subpoenaed the records, that information was available to us. So we put it through the medical process of the QME and said, does this have an element that would prevent you from saying the cancer is work-related, or would it still lead you to say it's not work-related? So it would help with the determination, basically. Peter, we're going back to you.
Okay, thank you, Sherri. And here is the federal statute, Americans with Disability Act, the ADA, the acronym ADA, and this is the U.S. Department of Labor. So again, it has protections against discrimination, prohibits discrimination against people with disabilities in several areas, and here are the areas: employment, transportation, public accommodations, communications, access to state and local government programs. So all those protected categories also apply to all these different areas here, public accommodations and the like. And here's some differences between the two. So we've got the state FEHA statute, and we've got federal ADA. So FEHA requires all employees with 5 employees or more to reasonably accommodate the disability. In the ADA, it's 15. So ADA, you have to have at least 15 or more to reasonably accommodate a disability of an employee, whatever that disability might be. And that reasonable accommodation requires meeting with the employee under FEHA. It's called the interactive process. It's basically just meeting with the employee, putting their work restrictions on one side of the table, their disability on the other side, and to see if that can be accommodated in some way. And here, and this is a very important distinction on the FEHA side. On the state side, the statute of limitations, where you have to make an administrative claim, you have to exhaust administrative remedies on whatever your disability is. In the past, it was 1 year. So you had to go to the Department of Fair Employment and Housing, file your complaint within 1 year of whatever the disability that you were alleging as the employee. But that changed in 2019, and they changed it to 3 years. So that really opened up claims for workers, because 1 year, that could go by and you may miss that statute of limitations. If you don't exhaust it with the Fair Employment and Housing Act department, then your statutory claim would be barred. But now with 3 years, it's really opened it up, where that's a much longer statute of limitations, of course. Okay, we can go to the next slide. And here, well, and actually the right to sue letter, and it comes up again here as well. In the state case, if you get in there, well, now within 3 years, so that's not a huge problem anymore. They will, the Fair Employment and Housing Act representatives will investigate your claim and then ultimately issue, if they can't settle it, for example, with the employer, they will issue a right to sue letter, and then you have 1 year from the right to sue letter to go to state court, and then you get to file your complaint at whatever court is your local court. The EEOC is the same right to sue letter, but only to be filed in federal court. Also, statute of limitations much stricter there, only 6 months. 6 months for your ADA claim. So that has to be filed very quickly, or you will not be able to file a federal statutory claim. Okay, I'm going to pass it to Sherri.
Thanks, Peter. So what are the takeaways from our history lesson? They're actually the foundation of a 132a petition are based on the protections and the definitions of disability under both California FEHA laws and federal ADA laws. Vulnerable areas, and this is where we cross over in your claims process, are return to work. We see a lot of 132As filed in return to work if the employer can't accommodate. We see a lot of layoff cases that end up the employee says that they were discriminated against, and employees with a performance issue. And there's a large, vast amount of claims that an employee is in the process of being terminated, and they will try to protect themselves and file a discrimination case. So let's talk about return to work, and Peter already has mentioned the interactive process, but we'll kind of go in more detail. So employers are responsible to make an active and good faith search for return to work through what's called an interactive process. Now, some employers are better than others in doing this, but we try to give them the steps and help them along the way. And if you know them a little better, maybe you can help them a little more. It helps your claims, certainly. So interactive process is the way employers and employees determine whether what is called a reasonable accommodation can be made. So here's this process, here's the steps. Recognizing and accommodating a request. So the recognition that an accommodation needs to be made comes from a medical. And looking at that medical and looking at the restrictions allows the employer, once you offer that information to them, to make a determination. Can they reasonably accommodate this person? They have to go through a process of gathering information. What job titles and duties do they have that's in their organization that they can accommodate a person with? What size of company are they? The smaller companies have more difficulty in determining if they can accommodate someone, whereas the larger employers are actually really more expected to provide some type of modified position. Exploring accommodation options is the next step. And that is done with the employee. The employee doesn't have to come in to the employer. They can be on the telephone if represented. They certainly can have their attorney join them. A lot of applicant attorneys say, no, go ahead. You know, they're still their employee. They still can discuss this very important issue. They can't talk about the claim per se, but they can speak about return to work. So then jointly, and the employer always has the control on this to determine whether or not they can accommodate, but they choose an accommodation. And then they implement the accommodation, and they do that in writing. And there are forms, if someone is MMI, there are forms, which we'll cover in the next couple slides, that need to be filled out to make that offer. And then they monitor the accommodation. Some employers do a great job at this. They have, you know, they kind of look out for the employee and make sure they're not trying to do more than they should do. And they also are trying to protect themselves by disallowing an employee to re-injure themselves. So they have what's called maybe a return to work plan. So let's cover the return to work supplemental job displacement benefit. It's due unless a timely offer can be made for that return to work offer that we just talked about. And here's kind of the statute to this. Labor Code 4658.7, and it's on or after January 2013. The supplemental job displacement, what we call voucher, is in the amount of $6,000. And that is due 20 days after the expiration of time for making an offer, unless and here's the kind of the guidelines. Offer for regular, yes, we still have to make an offer for regular work. Modified or alternative work is within 60 days after you receive, claims folk that are on this call, the MMI report of either the PTP, the QME, or the AME. And then claims needs to provide the reporting doctor with a job description of regular work, proposed modified work, or alternative work. And the physician will report an appropriateness of the proposed job and the form they use. There's two separate forms. We will cover another form in a slide coming up here, but the form for the return to work offer is 101.33.36. That's the physician's return to work voucher report. They're going to tell you whether or not it is appropriate. Hi, Tammy, I see you on.
We have a great question, actually. If the employee has multiple claims, is the employee entitled to a voucher for each claim?
Well, that's such a great question. If the claims are separate and individual, and it is with no respect to whether they, in the old days, if something became MMI at the same time, you had things that you could do where you kind of combine the disability. Now it's all different, and it doesn't matter if they become MMI at the same time. There are actually two cases. The first case is called Silva, and it's Silva versus LSG Sky Chefs. It's a 2015 case. And essentially the judge said if there's permanent disability awarded, they're entitled to a voucher if the employer can't accommodate. The second case is more recent. It's 2017, but it's Cessna versus Residence Inn by Marriott. And that essentially says that you have to be timely employer with your offer if they have PD, and if the offer is not timely, they're entitled to a voucher on each individual separate claim. So I hope that kind of gives you some guidance. I think it's a complex situation, and in a lot of ways it doesn't make sense. But you and I both know, all of us know, that some applicant attorneys file multiple cases. If you have a long-term employee, you may have 4 or 5 specifics, and you may have a CT. So there is something to look at, and each case individually to find out. And I don't know the answer if you can have 5 vouchers, because I've never seen that done, but I know that there have been a couple good guidance cases that say you can have 2. Okay, so we'll move on. Return to work forms. Claims to forward form to the employer. That's important because they won't probably know what to do unless you talk to them about it. To inform them of the restrictions. And then the employer and claims is to send out a regular offer on, and here's the form number, form WCAB 10118. So the regular work is on a different form than the modified or alternative. Now, modified or alternative is under WCAB 10133.53. And all of these forms can be seen on the DIR website. So if you haven't seen a form before, I'm assuming claims folk have, but if your employer needs to see one, they can go on the DIR website as well to understand these forms. So bottom line, and this gets frustrating at the board, and I've seen several cases that this happens, and the claims team is pretty frustrated, employer is frustrated, but if the offer is not timely or on the correct form, that voucher will be due. So let's talk about layoff rules, shifting gears just a little bit. Your employer may not know, and this is why we want to talk to you. There is an act, Cal Warren Act, and it's under Labor Code 1400 through 1408. And generally, an employer may not order a mass layoff. We've had mass layoffs of over 500 people before, or a relocation where they move out of state, or a termination unless 60 days before the order takes effect. They give written notice to all of their people affected, and also EDD. You need to include EDD, so EDD is prepared for the onslaught of claims that will be filed. There are substantial penalties for failure to give this written notification, and if the employer gives notice and the employee files a claim, is that post-term? I think that's a legal issue to think about, and it would be fact-based. So let's go on to my favorite topic, performance issues. Again, 37 years in claims. I've seen a lot of cases with post-term claims, termination issues, and you can see it coming. So this is when your employer needs to follow the process of documenting performance. Again, some employers do a lot better than others. We can always just encourage our employers as claims folk and as attorneys to give us that information. So what do? They counsel the employee. They try to offer the employee information that specifies how do I need to improve. And they document a series of write-ups. Let's say it's a repeated offense, or they're repeatedly not taking the coaching that's being given. And assistance by the manager. That means continual monitoring. Just as we spoke in the other slide, the managers need to be involved with the employees. And the goal is to improve. So the manager needs to document whether or not they're improving. Are they following procedures? Are they getting better at their skill? And again, some employers do better than others, as I mentioned, but it's something that we in the industry, the attorneys and the claims folk, can try to help our partners in this, the employers. An employee is more likely to file a preventative claim to preserve employment, and I've seen that many times, and I'm sure claims folk and attorneys have as well. And it's harder to terminate after a claim is filed. It's not impossible. Peter would certainly tell you that, but you're more vulnerable to a 132A, and a lot of employers make a conscious decision to not let them go based on not wanting to get at the 132A filing. So to continue, you're more likely to start seeking treatment from private health cares providers if they have it, and mention harassment by the employer or injury in body parts. They're building their case. Some employees seek legal advice before they file a claim. And I don't know what firms do this, but I know from particular cases that I've handled, they were given advice in advance to say, go ahead and seek treatment through your private health care provider and start talking about what that terrible employer is doing to you. And what this does is this makes overcoming post-term defenses, continuous trauma, more difficult for us. It's not impossible, but if there's medical treatment that is sought for the body parts they're alleging, you're going to have a difficult time saying that it's a post-term claim. Doesn't mean you don't have defenses, but post-term, at least in my experience, is relatively out the window. If terminated, more likely to file a retaliatory post-term case, likely to file multiple cases, likely to drag it on, right? They're mad, so they want someone to pay, or embarrassed even. Create the picture of the employers out to get them. So every turn of events, every corner is thought to be a discrimination and vulnerable to filing 132A, along with FEHA, or if they're federal employees, an ADA case. And really, finally, for me, return to work, layoff, performance issues. What's the impact on claims? You have angry employees. They may want to have the employer pay, get revenge. That's not a legal term, it's my term, but they want them to pay. They're mad, they're angry, they're embarrassed, and they want to seek those benefits within the work comp realm. Applicant attorney goal is to build the value of his or her case, and you're likely going to have protracted litigation and possible multiple QMEs. More likely to go after 5814s when the employee is mad. They may be seeking treatment that is with a non-MPN provider, and those providers may be saying they're temporarily totally disabled, where your MPN may not say that. So even if you have a right to delay or deny benefits, it doesn't mean the applicant attorney can't use their medical and seek a 5814 penalty. Harder to settle the case with the angry employee. And if a discrimination case is filed, the monetary value is up to a sum certain, determined by the ultimate value of that compensation paid. And it's increased by what claims disputed, and you have a lot of TD issues in that. And Peter, I believe I'm turning this back over to you.
Okay, thanks, Sherri. So here's the first civil type process crossover. This is the 132A discrimination petition. It's a labor code section, labor code section 132A, and it is the policy in California that employers cannot discriminate against workers who are injured in the course and scope of their employment. And if an employer does discharge or threaten to discharge or discriminates against an employee because they have filed an application for an industrial injury, or they're making their intentions known to file a petition, and then an employer tries to terminate that person to get rid of that work comp claim, that's not going to work, because that's exactly the protection of this 132A petition is. It protects an employee who is filing a workers' compensation claim and cannot be discriminated or terminated. And that's the thing. Well, I shouldn't say usually, but there's a lot of terminations that result in these 132As, but it doesn't necessarily have to be termination. It can be any form of discrimination against the employee, changing hours from a day shift to a night shift because the employee will likely not be able to continue working that shift. That would be a 132A if the employee had made their intentions known that they had an injury of some kind. So it's not just termination. Okay, we can go to the next slide. And then, this is just the technical part of it. It's if the employee has also received some sort of rating, or this would be post filing of a claim, of course. Then there would be a rating, an award, or a settlement, and then you terminate the person, after they settle their work comp claim. Of course, that's wrong. That's against the labor code. That would cause problems for your insureds, the employer. And also there's misdemeanor charges that can be brought against the employer for terminating a worker who's filed a work comp claim under 132a. Okay, next slide, please. And here is the, this is a little bit different. This code section is against the insurer, against all the carriers out there, all the work comp carriers. If the insurer threatens the insured to cancel their policy or raise their premiums unless they discharge an employee who's going to, or terminate an employee who's going to file a claim, that would be a misdemeanor against the insurer. But that's a real outlier situation where an insurer, a carrier, would threaten the insured and say, hey, you've got to terminate this person because they're filing a work comp claim. I've never seen that happen. That's a pretty extreme situation, but if it happened, that would be a misdemeanor against the insurer. That would be a $10,000 penalty potentially, and the worker could be reinstated and reimbursed for lost wages, and that would all be on the insurer, not the employer, not the insured. And this is further. This is the further part of the code section. If the employer again discharges or discriminates in any way against the employee who intends to, testify regarding a work comp claim, that could be guilty of a misdemeanor. If you're taking those kind of actions against an employee, again, to try to prevent some type of work comp claim, that's against the statute. That is a violation of the statute. Okay, we can move to the next one. And again, here's the same issue where the insurer would be threatening the insured because an employee is testifying in another employee's case. Again, these are so rare. I haven't seen one. I have not seen that happen with an insurer. That's a good thing. Okay, next slide. And here's the penalty section again under Labor Code section 132a under our discrimination petition in the work comp jurisdiction. It's an increase of the employee's compensation by 1/2, but in no case more than 10,000. So at least there is a cap. There's a cap on the damages in the work comp jurisdiction. So that's a good thing. $10,000 cap, costs and expenses of $250. But here is the big ticket item here is reimbursement for lost wages. That can get up into big numbers. Well, of course, reinstatement. You'd have to reinstate the person. That can cause problems for an employer too, as well. But the bigger issue is reimbursement for lost wages, as all our defense counsel out there know, and our adjusters, our work comp carriers. These cases can go on for a long period of time. So if someone was terminated and then they file a 132a because they felt they were discriminated against and it didn't go to trial for 4 years, 5 years, 6 years, they'd be entitled to those lost wages for 5 or 6 years. That's a big number that would be out of pocket for the employer, because these claims are not covered by the work comp policy. So you want to protect your insured there too, because they would be paying for that, and the policy would not reimburse them for that. That has to be that reimbursement is strictly out of pocket for the employer. So that's can be a big number as these cases drag on sometimes, as we know. Here is again the reimbursement, the reinstatement issues, the damage aspect of it, and then at the bottom of the slide there is the statute of limitations. So that's 1 year has to be, this 132a petition has to be filed within 1 year of the discriminatory act. So if it's a termination, you have to file your 132a within 1 year of that termination date. So every time I get a 132a, I always check, okay, when did, I look at the personnel file. When did they get terminated? Okay, let's look at the 132a petition itself. Was it filed within a year? Okay, it was. Then they're able to proceed. And here the WCAB has the power over all of these matters, these 132a matters, but the penalty phase there, almost all of the penalties, but the misdemeanor penalty, no, the WCAB doesn't have jurisdiction over the misdemeanor charge. They'd have to refer that to the Labor Standards Enforcement Board or the Office of the Public Prosecutor, the Labor Commissioner. Again, don't see that I don't think I've seen that happen where a WCAB judge says, okay, this is a 132a. I'm gonna refer this to the Labor Standards Enforcement for a misdemeanor charge. So it can happen though. I again have not seen that happen. And here I was saying, the 132a, they last a long, they can last a long time. This is a case that I still have going here. It was a layoff case. So 19 employees get laid off at this factory setting. One of the employees, who's the applicant, refuses to sign the severance agreement. All the other employees got a severance agreement. They gave him, I forget the exact amount, but $1,000 to $2,000, something like that, a severance payment. It actually could have been more than that. But this one employee said, no, I'm not going to take it. And he files a 132a claim and says, I've been discriminated against, when the facts don't support it because multiple people were laid off. It was an economic decision by the employer, but the applicant still files the 132a. That case is going on since 2015. The underlying case still not settled, although the defense attorney is working on a settlement, but it hasn't happened yet. So that's 8 years, as I mentioned, 8 years of lost wages. Well, this gentleman made about $30,000 a year, so 30 times 8, that's $240,000 potentially he could argue is owed in lost wages. So that's a big number. And that's what drives these cases with these applicants' attorneys. They use it as leverage against defense counsel in settling the case, and against separate counsel, myself in this case as well. Okay, we can go to the next slide. Okay, so here's a totally different topic now. We're switching gears to serious and willful. So this is the safety aspect of the industrial injury, that where obviously employers have to provide a safe workplace. However, if they don't provide a safe workplace and there's some injury based upon their conduct, the employer's conduct, then a serious and willful petition can be filed against the employer. And this, again, not covered by the work comp policy. The carrier will not reimburse the employer if they have to pay money to the applicant for a serious and willful. So again, this is out of the employer's pocket. So what does it take? Well, it takes more than negligence, more than gross negligence. It takes quasi-criminal behavior. Well, what's quasi-criminal behavior? A Cal OSHA violation, something where some violation of the Cal OSHA standards, which are codified, they're California Code of Regulations, Division 8, and all the multiple sections in the California Code of Regulations. That's where Cal OSHA is. So the applicant will use these Cal OSHA violations if they're assessed against the employer as the basis for the serious and willful petition. So you have to watch out for that. Okay, we can go to the next slide. Here again, we have a 1 year statute of limitations. So 1 year from the date of injury, and since this is serious and willful, it could be a death claim. So date of injury or death, 1 year, you have to file it. Again, I always look at, well, when did the injury occur? Okay, let's look at the serious and willful petition. What's the date there? Was it within 1 year? Yes. Okay, you can go forward. Always important though, as even the adjuster or the employer, to make sure it was filed within 1 year. Of course, you'll have your attorney right there helping you with that. Okay, we can go to the next slide. And then here is the basis of it, the support of it. It's a violation of a safety order, which is usually a CalOSHA violation, that California Code of Regulations, Division 8, many different subcategories of protection for workers, so that the employer has provides a safe working environment. So they can use any one of those code sections. And again, the violation of the safety order has to proximately cause the injury or the death. So whatever that is, if it's a guarding situation, guarding equipment, and someone has a crush injury or amputation injury, I have those pending right now where there's an amputation. That would be obviously the basis of this serious and willful code section. And again, it has to be more than negligence, more than gross negligence. It has to be some sort of obvious, serious failure on the part of the employer to correct some type of dangerous condition at the workplace that that was known to them, and they violated it. And this again is the labor code section. It's 4553. This is 4553.1. It's all in the labor code, and it requires the employer again to provide a safe workplace for the employees. And the penalties. Okay, so here's obviously important. Again, this would come out of the employer's pocket. Does not have to be reimbursed by the carrier. They have no duty to do that. So the employer is on their own. And what is that? Well, it's the amount of compensation. What is the monetary value? It's the amount of compensation recoverable by the applicant to be increased 1/2 if the allegation is proved. So you'd take your TTD that was paid, that's compensation. Medical that was paid, future medical, that's all compensation to the worker. Obviously the CNR, the compromise and release, add all those numbers together, whatever that is, and then whatever is 1/2 of that would be the penalty against the employer if facts of a dangerous condition are proved. So it could be a big number, especially in a death claim. Death claims, they're $300,000 or so. Well, half of that, $150,000. I have one of those right now. It's $150,000. That's a big number against the employer, out of their pocket, no insurance. Okay, we can go to the next slide. And it can't be just a coworker that causes this dangerous condition. So that helps the employer a bit. It has to be a managing representative of the employer. If the employer is a partnership, in this case, it has to be one of the partners, a managing representative or a general superintendent, someone in charge, not just a coworker who created some condition. It has to be more than that. And here again, if it's a corporation, the wrongful conduct, the creation of this dangerous condition that was not remedied in any way, and the employer knows about it, would have to be on the part of, in this case, if it's a corporation, executive managing officer or general superintendent. Again, someone in charge who turns a blind eye to what's an obvious dangerous condition at the workplace. Almost like a punitive damages situation if you were in civil court, something malicious really by the employer. And here's a case. Here's one of the death claims. I have several of them. Here's a death claim that I have with a serious and willful. This was a rolling gate, however, that is one of those big gates you see sometimes at some of these businesses where you have to pull it and it's on wheels. and the worker at the end of the day pulled the gate out. There was a metal stop that would stop the gate from going past the guards that hold it in place. Unfortunately, the weld on the bottom of the stop just failed. So then the gate was able to be pulled past the guard that holds it in place. And then this 5,000-pound gate is now just in the wind. It fell over on top of the worker, crushed him, killed him, and resulted in, it resulted in a death claim at the board, which was about $324,000. And, so half of that, you do the math, that's a big number against the employer, $150,000 or so that they filed based upon the Cal OSHA violation, because Cal OSHA came out and said, hey, you employer, you should have checked this gate and made sure it was safe. Although we're fighting that with our experts because the gate had been maintained properly, and this was a weld that broke. It was not obvious to anyone. But again, that's our fight on that one, to prove that they didn't know that a weld on a gate would give way. That wasn't easy to see by just looking at the gate, because it looked fine. But the claim is also went to civil court too. There's also a wrongful death in civil. So there's another attorney, that's another law firm that's handling the civil part of it. I'm handling the serious and willful for the employer, based upon that Cal OSHA violation. So that's going to be, a fight against the applicant's attorney on that to see whether he can prove that the employer, had knowledge of this faulty gate. Oh, here's an interesting code section too that's not used much but could be used. This is Labor Code Section 4551. This is willful misconduct of the injured employee. If the injured employee acts reckless in some way, basically causes their own injury, you as a carrier and as your defense counsel representing you at the board could file a serious and willful petition against the employee, which would reduce his or her recovery by 1/2. Now, it doesn't apply in death claims. It doesn't apply in 70% PD value cases or more, and it doesn't apply to a worker who's 16 years or young. But so it doesn't apply in those cases. But there's a wide area there in the middle where it could possibly apply to some employee acting recklessly. You could file you could file the serious and willful claim against the employee for leverage against them. Okay, I think we can go to the next slide. I think that is our final slide, and I believe so. I believe that is the last slide for today.
Thank you, Peter. I do have a couple of questions for both of you. I think this first one's probably for Peter. If two employees are involved in horseplay and one of them is hurt, can that be a scenario for a serious and willful against the employee?
Yes. So under that 4551, you could make the argument, look, this employee caused their own injury by acting recklessly, by engaging in horseplay, engaging in some dangerous activity. Now, of course, the facts would have to really support some sort of reckless behavior on the part of this employee, maybe horseplay on an elevated platform, for example, something clearly dangerous that would cause an injury. Then you could file that 4551 serious and willful petition against the employee, which would result in a potentially reduction of 1/2 of the benefits that the employee could receive. And that is a way to force the, it's not going to force a settlement, but it gives you a little leverage against the applicant, because they use these serious and willfuls against us defense counsel all the time. So it would be a nice way to use it against them as part of a compromise and release, for example.
I actually have something I want to add there, if you don't mind, Peter. I had a
Sure.
case many years ago, and it was horseplay, and there was two gentlemen, and they were in the parking lot, and the building that they were very close to was an all glass building, and of course they were tossing the football back and forth. It was not employer condoned. They didn't know that it was going on, and the football, you know, as we all do who try to catch football, sometimes we miss it. Well, it went into the glass building, and I think the glass must have been weak, but the glass actually broke and injured the guy trying to catch the ball. There was a serious and willful against the employee filed, and actually we did decrease his award. So I have not seen many of those in my many years, but it can happen. So just kind of a food for thought on that.
That's a good example, and it worked. It was, you were able to reduce the compensation by 1/2 by someone being somewhat reckless at work. But that's a good example exactly of that code section.
Okay, and I think we have a couple more minutes, so I was just going to give you guys one more question, if that's okay. I don't know if you'll know the exact percentage of this question, but I thought it would be kind of fun to discuss. What percentage of 132A claims filed have any merit? Because it seems like they are often frivolous. This is what one adjuster is saying.
That's a great question, and you're right. I don't know if I can put a percentage on it, but I can say yes. Let's say a majority can be frivolous. They're using it strictly as leverage to get a bigger settlement from the carrier. And yes, they throw it in many cases where there's no facts to support the discrimination. So I would say a majority we could argue are frivolous claims. More than well, let's put a percentage on it. More than 50%, for example, I would say are frivolous, and you still have to fight them though. The employer still has to fight them. The ones that the ones that are filed after layoffs, for example, and I still have them going. I mean, those you could argue those are frivolous. There was a layoff of multiple people. It wasn't just the worker, and they still file the 132A. So yes, that is a problem. I agree. That's why the employer best to go through all their, as Sherri mentioned earlier, go through all your your performance issue, your disciplinary procedures, document it well in the file so you have a good defense against it when it gets to trial, when it gets there.
I'll reach out and say, I'm going to give a number, 37 years in, and I would probably venture to say 10 to 15% of the 132As that I've seen had some merit. Probably closer to 10%, but not many. Mostly just to do what you said, Peter, to try to escalate the value of a case. But those that do have merit are the big ticket items. So that's what you have to watch out for.
Right. Those are the ones that I've had to try, that I've had to go to trial on because there's lost wage, as we mentioned, right? The big ticket, the lost wages, and then they want their, $240,000 in lost wages, which is a huge number at the board, as all defense counsel know, for that type of claim. So yes, those are the ones that go forward with a big delay between the act itself and when the case finally got to trial, because then they can argue for all these lost wages. If it's a fairly short period of time where there's the layoff and then the case somehow goes to trial quickly within a year or so, obviously your lost wages would only be a year or something like that. That's a little bit easier to handle. But the ones that, like mine, with 8 years have gone, that's a little bit tougher.
Okay, great, thank you. It's always a pleasure to learn from both of you. Thank you so much for joining us today. We really appreciate it. And for everybody listening, thank you so much for joining. I hope you all have a great rest of your day. Thank you very much.
Thank you.